Good, can I help you?
Got your driver's license?
What do you need my driver's license for? What'd you pull me over for?
What's that?
What'd you pull me over for?
For your threats that you made to one of our officers.
That's not a threat. What threat? What threat did I make to an officer?
I need your driver's license, proof of insurance.
You need a reason to pull me over.
I just gave you that.
For what threat? I didn't make any threat to any officer. I haven't. No, I am not, because I did not break the law.
So you're not going to give me your driver's license and proof of insurance, is that correct?
For what?
I just told you.
For what threat?
The allegations are not serious at all for a police officer to do something like this.
Flipping an officer off is not a crime.
A threat to an officer is, I'm not going to...
Flipping an officer off is not a crime. Flipping an officer off is not a crime. It's a constitutionally protected activity. Right?
Hop out or I'm going to break your window.
It's a constitutionally protected activity to flip an officer off.
That's fine. You can flip him off. You can't make threats to him.
I didn't make... What threat?
This is
What
your
threat?
last chance or I'm gonna break your
What
window
threat?
and arrest
Okay,
you.
first, tell me what threat I made to him. What threat?
According to the uploader, the man behind the camera claims he gave an officer the bird. If true, the officer either heard something different, saw something different, or foolishly took it as a threat.
What threat did I make to him? What threat did I make to him?
Driver's license, get out
I
of the
will.
car,
Here's
get under
my
arrest.
thing.
Out of the car.
Under arrest for what? Under arrest for what?
Failure to comply with
Are you kidding me? What did I do? What law did I break? What law did I break? I want my phone. I'm allowed to record you guys.
The failure to comply charge, while a man disputes an alleged middle finger being metaphorically thrown an officer's way, is just the icing on the cake of cops finding a charge for anything they can. The man also has a point about it being constitutionally protected. Here's how we got to this point legally. A woman in Michigan, Deborah Cruz Gullius, was pulled over in 2017 for speeding. The officer showed leniency, writing her up for a lesser violation known as a non-moving violation. As she drove away, apparently insufficiently appreciative of the officer's gesture, Cruz Gullius made a certain gesture of her own, or as the court put it, she made an all too familiar gesture at Officer Matthew Menard with her hand and without 4 of her fingers showing. Menard was not amused. He pulled her over again and rewrote the ticket for speeding. Cruz Gullius sued, arguing she had a First Amendment right to wiggle whatever finger she wanted at the police. In a ruling this week, the U.S. Court of Appeals for the Sixth Circuit agreed with her. Fits of rudeness or lack of gratitude may violate the golden rule, wrote Judge Jeffrey Sutton for the 3-0 panel, but that doesn't make them illegal or, for that matter, punishable. And once the first stop ended, Menard needed a legit reason to pull the driver over again. Detaining her without one constituted an unreasonable seizure in violation of the Fourth Amendment, the court said. Cruz Gullius did not break any law that would justify the second stop, and at most was exercising her free speech rights, the court wrote. It is well settled that what Cruz Gullius did is protected by the Constitution, the court said. Any reasonable officer would know that a citizen who raises her middle finger engages in speech protected by the First Amendment, Sutton added. In response, Officer Menard argued for qualified immunity, a legal doctrine that can protect officials from lawsuits if they can show that the rights they violated were not clearly established, essentially that they were acting in good faith. But a district court denied that motion, and the appeals court did the same. So it has been affirmed raising your middle finger to a police officer is your First Amendment right. Menard analogizes actions to a prosecutor who might renege on a plea deal if a defendant behaved offensively, but the court wasn't swayed. The facts here are more like a judge who hauls the defendant back into court a week or two after imposing a sentence based on the defendant's after-the-fact speech, the court said. Menard, in short, clearly had no proper basis for seizing Cruz Gullius a second time. The court's ruling means Cruz Gullius' lawsuit can proceed in a lower court. Joanna C. Schwartz, a law professor at the University of California, Los Angeles, and an expert on police misconduct litigation, noted that Ms. Cruz Gullius and a few others had their rights recognized only after they went through the trouble of bringing their cases to court. The right is there, but the enforcement of that right is a more complicated matter, she said, noting that many people who experience police misconduct do not report it. There is a gap between what the Constitution allows and requires and how police behave on the street, and getting from the street to the courthouse is a long and expensive process.